Greetings from wet and gray southeastern Washington. I wanted to touch bases on a couple things that I heard in Miss Potts Live the other night about the alibi demand from the state and the DNA. So let's get started.
Right. I agree with that. If they had solid evidence, they would not be sweating his alibi. Yeah, I agree. Considering his defense had already stating in the beginning that they basically, their entire defense is going to rely on whatever the state produces in their discovery, and they plan to use the state's case to prove Brian's innocence. They never once said they were using an alibi as their defense. Okay. And yet somehow the state was able to manage to, well, we need an alibi and they need to disclose his alibi and blah, blah, blah. Technically, the defense was never going to use the alibi as a defense. The state demanded one, which is wild to me. What do you care about his fucking alibi? I thought you had everything you need on him.
Well, actually, per Idaho state law, as part of discovery, the state must ask the defense if they will be using an alibi defense. And then the defense either needs to say yay or nay. And if they are going to be using an alibi defense, then that information has to be turned over to the prosecution within a specified time frame. Now, Anne kind of tried to have her cake and eat it too. She pretty much waffled with her initial response and didn't say yes or no, which you can't do. It's either got to be a yes or it's got to be a no. You're either saying you're going to use that alibi defense or you're not. And so that's why the state sent out another reply trying to get her to commit on it. So let's look at the filings. Let's start first with Idaho law. It says, notice of defense of alibi. At any time after arraignment before a magistrate, upon a complaint and upon written demand of the prosecuting attorney, the defendant shall serve within 10 days or at such different time as the court may direct upon the prosecuting attorney a written notice of his intention to offer a defensive alibi. Such notice by the defendant shall state the specific place or place at which the defendant claims to have been at the time of the alleged offense, and the names and addresses of the witnesses upon whom he intends to rely to establish such an alibi. Within 10 days after receipt of the defendant's notice of alibi, but in no event less than 10 days before trial, unless the court otherwise directs, the prosecuting attorney shall serve upon the defendant or his attorney a written notice stating the names and addresses of the witnesses upon whom the prosecution intends to rely to establish the defendant's presence at the scene of the alleged offense and any other witnesses to be relied on to rebut testimony of any of the defendant's alibi witnesses. If prior to or during trial a party learns of an additional witness whose identity, if known, should have been included in the information furnished under subsection 1 or subsection 2 of this section, the party shall promptly notify the other party or his attorney of the existence and identity of such additional witnesses. Upon the failure of either party to comply with the requirements of this section, the court may exclude the testimony of any undisclosed witness offered by such party as to the defendant's absence from or presence at the scene of the alleged offense. This section shall not limit the right of the defendant to testify in his own behalf. For good cause shown, the court may grant an exception to any of the requirements of subsections 1 through 4 of this section. By law, here was the state's first discovery demand. And it's asking for everything they need to ask for in discovery. And you can see on page 2, in accordance to Idaho law, they state, further, the state hereby demands the defendant notice if defense of alibi pursuant to Idaho Code 19519 and Idaho Criminal Rule 12.1. And that was in May of 2023. Now, on June 9th, here was the defense's reply to the prosecution's request for discovery. And if you go to the next page, you'll see where she discusses the alibi demand. So she says Mr. Koberger has filed a contemporaneous motion for an exception, or in the alternative, of exception of time for notice of alibi. So at that time, she was not saying yes or no. She was wanting an extension to the alibi demand. And you can see the same day Anne has asked for a motion for the exception. And she's asking for a 15-minute hearing if the court is going to grant the exception. She says the defense needs time to make this determination and consider evidentiary rules. As such, Mr. Koberger respectfully requests an exception to compliance with 19519. So then on June 13th, the prosecution responds and says they understand that more time is needed, and they ask that it could be extended no later than July 24th of 2023. So then July 24th, the defense responds with this, saying that this is for the demand of alibi. And she goes on to state that the defendant's denial of charges against him does not constitute an alibi, but as soon as he offers evidence that he was at some place other than where the crime of which he is charged was committed, he is raising the alibi defense. Evidence corroborating Mr. Koberger being at a location other than King Road address will be disclosed pursuant to discovery and evidentiary rules as well as statutory requirements. It is anticipated this evidence may be offered by way of cross-examination of witnesses produced by the state as well as calling expert witnesses. So she's waffling, like I said. She's saying, well, if he offers evidence, then we'll have an alibi defense. Basically, if he doesn't, we won't. She's still not committing, which is just got to be frustrating the state at this point, because it's like either you're going to use an alibi defense or you're not. So on July 27th, the prosecution then again says, hey, if you are going to use an alibi defense, we need to know this, and this. So it talks about what's in code 19519 again, about specific place and specific names of witnesses, etc. He's saying what was submitted so far does not meet that criteria, and rightly so. So then Anne responds on August 2nd that they recognize, out of abundance of caution, that the court has the ability to exclude witnesses, and Mr. Koberger has indicated he anticipates corroborating witnesses. She then goes on to blame the grand jury route as the reason why she wasn't able to cross-examine witnesses. But I find that kind of interesting because although the defense doesn't have power to issue like search warrants on their own, they can issue subpoenas to witnesses on their own. So just like we saw, she subpoenaed Bethany and was supposed to talk to her in Nevada, going the grand jury route does not stop the defense from being able to talk to a witness. So to me, that's a pretty flimsy excuse there. So she then goes on to say corroboration of Koberger not being an 1122 King may be brought out through expert witness presentation. That analysis is underway. Then it says the defense acknowledges a vast amount of discovery has been provided. Discovery is received on nearly a weekly basis. So she's kind of using that excuse again of, oh, we had too much evidence to look through. And then finally she gets to Mr. Koberger was out driving alone. Corroborating evidence may come from cross-examination of state's witnesses. Corroborating evidence may come from presentation of defense experts. Mr. Koberger is aware of and will comply with continuing duty to disclose information. So she's asking for them to exempt Mr. Koberger from further inquiry. And he's requesting another exception at this time. So then, of course, at that point in August, we got the waiver of the speedy trial right. We got the trial canceled. We had all kinds of hearings happen, IGG, everything else. And Judge never made a decision about the alibi. It got lost in the shuffle and nothing was mentioned again until February when some deadlines were set. So after the scheduling hearing on February 28th, 2024, Judge put out that any notice of defensive alibi must be filed no later than April 17th, 2024, if defendant intends to offer a defensive alibi. So on April 17th, Anne finally replied with more of an alibi. This is where she talked about him driving in the countryside late at night and in the early morning on several occasions, pictures depicting the night sky, and that there would be partial corroboration from an expert witness, which is Cy. She was then claiming she would need more information from the prosecution in order to be able to have Cy corroborate these things, which of course we all know there was the hearing for the motion to compel to get the FBI CAS data. And on April 26th, the prosecution filed their response to the notice of the alibi demand, and this is where they objected basically to that alibi, saying it does not fulfill the state law. It lacks the specificity required by 19519. The state asked for the court to enter an order denying the alibi defense, and of course, nothing has been done to that yet. Anne never gave a reply to that order. Judge never gave a reply to that order, and in the meantime we went on with the change of venue, and now it's with Judge Hippler, and still nothing about alibi. But as you can see, it wasn't the prosecution trying to demand something for no reason. Per state law, as part of discovery, the prosecution must send a notice requesting that if an alibi will be used, that the defense has to turn over that information. And Anne tried to straddle the fence, and you can't do that. It has to be a yes or a no. So that's why the state kept pushing. And it has nothing to do with the state having weak evidence or not. It's just all part of state law.
Yeah. I think it's stupid when I hear people arguing, well, the IGG was just a tip. Nope. The IGG is how they were able to create the SMP that they uploaded to CODIS, right? Or STR, whatever the fuck it was. They uploaded to CODIS. This is how they got it. They had to do this kind of work to it to be able to upload it to CODIS.
Okay, let's have a little refresher on the order that the DNA profiles went in, because the IGG wasn't first. So let's go back to the state's protection order motion, and this is where they talk about the process. It says the ISP laboratory determined the DNA came from a single source and that source was male. Once law enforcement had the single source DNA from the K-bar sheath, they conducted what was called a short tandem repeat STR DNA analysis. STR analysis involves looking at 20 regions within the human DNA that allows law enforcement to make a direct comparison between two STR DNA profiles. So that is what they ran in CODIS. And then, of course, it says that no match was found in CODIS. Unable to find a match using the STR analysis, they decided to go the IGG route. So then this talks about how genetic genealogy does the SNPs, the SNP, the single nucleotide polymorphism, that they use for the genetic genealogy purposes. So the ISP utilized a private laboratory. We know that was Othram, and that laboratory developed the SNP profile. Then the FBI took that SNP profile and started working on the family trees and uploaded it to genetic genealogy databases. That's when they got a hit leading to Brian Kohberger's name. So at that point, because you can't arrest based off just IGG, because IGG, again, is just an investigative tool. It's a tip. They had to get another STR match, so that's when they used the dad's trash and got an STR profile from the dad. And of course, that came back showing that the DNA on the knife sheath could only be the male offspring of Michael Kohberger. Now, in the defense's own motion to object, they don't deny that this was the order of the process. They state on November 20th, 2022, Idaho State Police Lab in Meridian located DNA on the button of the sheath and performed STR analysis that led nowhere when it was ran through CODIS. So saying that the IGG was used to get the STR profile is incorrect. That is not how the order was done. They did an STR, which is the standard profile that's used by law enforcement to run into CODIS. Because Kohberger had never been arrested for a violent crime before, his DNA was not in CODIS, so they didn't get a hit. So they went the genetic genealogy route as an investigative tool. but they had to go back to STR again in order to make the arrest. So it went ISP Lab STR profile, Othram SNP profile, ISP Lab STR profile. That was the order. And so it's all in those court documents. It follows the process very well in the state's motion for protective order. And again, the defense has never denied that that's the order things went in. They also have yet to deny that that's Kohberger's DNA. So I guess we will see at these pretrial hearings what's going to happen with DNA. My personal opinion is it's not going to get excluded. Also, it'll be interesting to see if Hippler makes a decision on the alibi as to whether the defense needs to follow the Idaho code and be more specific, or if the defense is just going to come out after all and say, we're just going to try using a different defense at this point. There's a lot that's going to take place between now and next summer. So buckle up. And as usual, if there's something you want me to cover, let me know.